Thank you. Please be seated. Good morning and welcome to the Idaho Supreme Court. It is August 3rd, 2022. The date originally set to hear arguments on the merits of two petitions brought by Planned Parenthood Great Northwest et al. Against the state of Idaho, which came to include intervenor Scott Bedke et al. However, subsequent to this court scheduling a merits hearing this morning, the United States Supreme Court issued its ruling in Dobbs versus Jackson Women's Health Organization. Thereafter, this court vacated the original hearing in this matter and set a new hearing for today's date. Our hearing this morning is scheduled to deal with procedural matters surrounding these cases. All proceedings brought before this court under Rule 5 of our appellate rules involve what are clearly defined as extraordinary. This case is no exception, but this hearing today, while it may touch on the merits of the petitions originally filed by Planned Parenthood, is designed to allow the attorneys and this court to discuss specific procedural questions that were identified for the parties in this court's order-setting hearing filed June 30, 2022. Thus, our discussion today may be different than what those who came to this hearing or who are watching via the internet may have expected. We provide this brief explanation to address any questions from the public in that regard before we begin. With that said, we are on record, as noted, in two special matters, Planned Parenthood Great Northwest et al. Versus State of Idaho and intervenors. These two matters are numbered 49615-2022 and 49817-2022. In both cases, the petitioners are represented by Michael J. Bartlett, local counsel, and Alan E. Schoenfeld and Rachel Kraft, pro hoc vice. Good morning. Good morning. It's my understanding Mr. Schoenfeld will argue for the petitioners. Is that correct? The respondent, State of Idaho, is represented by Megan A. Larondo and Dayton P. Reed. It is my understanding that Ms. Larondo will argue for the respondents. Is that correct? Yes, Your Honor. And the intervenors are represented by Daniel W. Bauer and Monty Neal Stewart. It's my understanding that Mr. Stewart will argue for the intervenors. Is that correct?
Yes.
Each side has been given 30 minutes to argue. Mr. Schoenfeld, I understand you've reserved 10 minutes for rebuttal. Is that correct?
Yes, sir.
The respondent and intervenors are splitting their 30-minute allotment equally. Is that correct?
Yes, sir.
With that, are there any preliminary matters prior to argument from either of the parties? With that, Mr. Schoenfeld, you may proceed.
Good morning, Your Honor. Mr. Chief Justice, and may it please the Court. The Court asked the parties to address three questions relating to the Idaho legislature's attempt to ban all abortions in the state. The parties and intervenors agree on the answers to two of these questions. First, this court should decide the legal issues presented and not return the cases to the trial court. And this court should consolidate the cases if the court intends to address common constitutional issues. The question on which the parties differ is whether the court should stay the challenge statutes pending a conclusive determination of their constitutionality. This court should preserve the status quo that has obtained in this state for 50 years and ensure that Idaho women have access to safe, comprehensive reproductive health care, including access to safe abortion care. The statutes before the court, SB 1309 and the total abortion ban, trample numerous safeguards secured by the Idaho Constitution. Petitioners have made a strong showing on the merits because of the patently unconstitutional way the legislature has acted. Stays from this court are necessary to ensure that Idaho women are not irreparably injured by the complete unavailability of abortion care in this state. I'll start with the stay with respect to the total abortion ban. I recognize that the court doesn't have full briefing on the merits yet with respect to the second challenge we filed, but what matters for the question before the court today, whether to stay the statute pending a full determination on the merits, is that petitioners have presented serious questions going to the constitutionality of the statute. And given the gravity of the interest here, that should suffice to warrant the stay. The total abortion ban violates the Idaho Constitution because the Constitution protects a woman's right to decide for herself whether to carry a pregnancy to term. I'll return to that argument in a moment, but let me start with a more fundamental defect in the total abortion ban, which is its impossible and irremediable vagueness. The statute includes an outright prohibition on abortion and then two affirmative defenses, reflecting the legislature's judgment that an outright ban on all abortions is not defensible. But the affirmative defenses that the legislature has written are so vague as to be self-defeating. No healthcare provider would subject himself to criminal penalty on the hope that he might persuade a jury that the affirmative defense bars his prosecution. Take the first defense, which is available when an abortion is, quote, necessary to prevent the death of a pregnant woman. That language gives no indication of how imminent or substantial the risk of death must be in order for the provider to feel confident that he can provide an abortion without risking prosecution, jail, and professional sanction. Must the woman's death be certain? Must it occur the next day or week? Suppose a patient with pulmonary hypertension has a 30 to 50% risk of dying with ongoing pregnancy. Is that enough? The statute gives no guidance on any of these life or death questions, making it surpassingly unlikely that a doctor would perform an abortion in reliance on an affirmative defense, and therefore making it likely that women who need abortion care to save their lives or protect their health will be denied that care. The statute is critically vague in another respect, too. Both affirmative defenses for rape and incest, and where abortion is necessary to prevent the death of the mother, require that abortion be provided in a way that, quote, provided the best opportunity for the unborn child to survive. But that's nonsensical. The statute defines abortion as a procedure undertaken knowing that it will cause the death of the unborn child. Especially early in the pregnancy, there's no way to provide an abortion in a manner that provides any opportunity for the non-viable fetus to survive. In other words, the exception is written, I apologize, it's not even an exception, it's an affirmative defense. It's written in a way that makes it impossible to comply with or invoke, ensuring that no provider will provide an abortion, even where the mother's life is at stake and even where the pregnancy is the result of rape or incest, because of fatal uncertainty about whether the affirmative defense would reliably be available.
Counsel, I'm wondering, does that qualify as a facial defect in the statute? Because I think it's not unusual to have statutes that don't lay out all the guidance for medical procedures. Typically, we have rulemaking and those kind of things. Medical bodies sometimes create their own protocols. Is that actually a facial defect here?
It is. This is a criminal statute, so you wouldn't expect any regulation elaborating the precise definitions. And there are other criminal prohibitions on medical procedures, including the fetal heartbeat ban, that do include definitions of the relevant provisions. What's missing here, and what is warranted under the Due Process Clause, especially where criminal sanction is available, is some specification of how you define these terms and how you operationalize them as a medical provider. And so the fact that there's no definition of these terms, and the fact that medical providers are left to guess about whether these affirmative defenses ultimately will be available, is what renders this void for vagueness on its face.
Would that same argument apply to the statute that creates civil liability?
I think we haven't made a void for vagueness challenge with respect to SB 1309. There is a due process challenge related to the specification of statutory damages, but we haven't challenged the underlying prohibition there. We've separately challenged on vagueness grounds the underlying criminal prohibition with respect to the heartbeat law. That's not before the court today, though. I should note that in order for there to be relief here, in order for abortions to be provided in the state, all three of these statutes need to be stayed pending conclusive adjudication of their constitutionality. The fetal heartbeat ban, the one that we filed the third challenge on, becomes effective August 19th because of the date of the judgment being entered in the sister song case in the 11th Circuit. The total abortion ban becomes effective August 25th. So there is this gap of 6 days where it's possible that the fetal heartbeat ban might be effective and enforceable under state law, but the total heartbeat ban is not yet enforceable. And of course, the total abortion ban supersedes the fetal heartbeat ban by operation of the statute. So just want the court to be mindful of that 6-day gap. But
before you go too much further,
yeah.
You just said that the total ban supersedes the heartbeat ban. Explain, based on the statutory language, how you view that to occur. And what I mean is does 8800, does that entire chapter go away? How is it going to function?
So my understanding from the language of the statute, which is not entirely clear, is the language of the statute is if both statutes are enforceable, the total abortion ban supersedes the fetal heartbeat ban. And that makes sense as a logical matter, just because if all abortions are outlawed, then any abortions performed after detection of a fetal heartbeat at or around 6 weeks would also be banned. But the statute makes that clear so that enforceable is, it's not entirely clear what enforceable means. So for example, if there are stays or injunctions, whether it's enforceable. But by operation of the language of the statute, as I understand it, is if there is no legal impediment to both statutes becoming effective, which could happen as early as August 25th, then the fetal heartbeat ban becomes inoperative. It remains operative, however, as the underlying criminal prohibition for SB 1309. So even if it is superseded as a matter of state criminal law, SB 1309 provides a mechanism for enforcing the fetal heartbeat ban civilly through the sanctions that it makes available. So it's a little bit...
Why is that true when the civil remedy section hinges directly on a violation of, quote, the chapter, that is to say 8800? So why, if the total ban supersedes the fetal heartbeat ban, why is there any civil remedy?
So it's a fair question. As I understand it, SB 1309, the civil remedy provision, rests on the underlying criminal prohibition for the 6-week ban. And I take your Honor's question to mean that if that is rendered unenforceable by virtue of the total ban becoming ineffective, then the civil enforcement mechanism is itself unenforceable. I'm very happy if that's the result. Obviously, the civil enforcement mechanism poses its own constitutional challenges. But if the end result of this is that the only statute that remains effective or could be effective upon the enforceability of all of them would be the total abortion ban, then I think it's probably right that this court need only stay the enforcement of the total abortion ban pending an adjudication of the constitutionality of the ban.
And given our conversation about the overlap between 622 and SB and the heartbeat bill, doesn't it make sense, even if we're talking about just vagueness issues, that this court should consolidate all these cases if we keep them?
Absolutely. I mean, we have no objection to consolidation, and certainly if it's the court's preference, I'm very happy to have them consolidated. I think the only point we were trying to make in responding directly to the court's question is that there are independent constitutional grounds for striking down each of the statutes or even for staying each of the statutes. If it economizes for the court or if it allows for consideration of all of these prohibitions together so that the court understands the way that they interrelate to each other and the way that they remain civilly or criminally enforceable, I think consolidation makes perfect sense. From our vantage point, the critical point is whatever procedural mechanism this court chooses with respect to consolidation or sending the cases down to the district court, the statute should remain stayed pending some ultimate determination on the merits here. So we have no objection to consolidation, and certainly for all the reasons that we've been discussing, that may well make sense. So I was talking about the need for a stay of the total abortion ban, and I'm happy to return to that. Obviously, the first ground on which the court could determine that there is a strong showing of success on the merits or the likelihood of success on the merits is with respect to our vagueness challenge. And that should suffice to show that petitioners have put the constitutionality of the total ban in question. The court need not consider, therefore, at least at this juncture, whether the Idaho Constitution protects a woman's right to decide whether to terminate a pregnancy, because the facial unconstitutional vagueness of this criminal prohibition suffices to doom it. But the text of the Constitution and the history of this court's interpretation of the relevant provisions all support the recognition of a fundamental right to decisional autonomy that comprises the right to decide whether to terminate a pregnancy. And I'll try to be brief on this point because we've laid this out in detail in our briefing. But we've laid out the constitutional provisions that support this view and the broad reading of those provisions that this court has consistently given. Article 1, Section 1, the inalienable and natural rights provision. Article 1, Section 13, the due process provision. Article 1, Section 17, the analog to the Fourth Amendment. And Article 1, Section 21, the reservation of rights to the people of this state. I won't retread the specific arguments that we make in the brief, but I want to address two specific points. The first is that the rights that this court has already recognized under the provisions I just mentioned, among them the right to procreate, a right to privacy that is broader in some respects than the right recognized under the United States Constitution, and the natural right to make decisions respecting one's body, are the very same rights that other state high courts interpreting similar provisions and similar constitutional traditions to Idaho's have concluded support the right to decide whether to terminate a pregnancy.
Counsel, I want to ask you about that, and I do so respectfully. I think we all understand the history here in Idaho. Abortion was a crime back in Idaho's territorial era, dating back to 1863. It was still a crime in 1890 when Idaho became a state. When the Idaho Constitution was drafted, and after it was drafted, it remained a crime. The only thing that changed was in 1973, we had Roe versus Wade, where Roe versus Wade found a federal right to abortion in the U.S. Constitution. It didn't find a right to abortion in the Idaho Constitution. So my question for you is, if there was a right to abortion in the Idaho Constitution, has it always been there, or did it somehow arise as a result of the Roe decision?
So I want to answer your question in two parts. The first is about the relevance of this long history of criminal prohibitions on abortion in Idaho. That was true in Kansas and in Tennessee and in Mississippi and Alaska and Michigan, all of which have state high courts that have identified a protection in the state constitution for abortion. And the Kansas Supreme Court in Hodes and Nauser, I think, does the most comprehensive job of addressing why the long history of criminal prohibitions on abortion in the state don't determine whether the right to abortion is implicit in the state's constitutional order. And the court in Hodes and Nauser gave a number of reasons, and I'll focus on two of them. The first is the constitutionality of those statutes was never tested under the state constitution. So the history of Kansas's criminal prohibitions on abortion went back to its territorial days, went back to its first enactment, went back to Kansas's decision to break from Missouri's historical tradition, all the way through to the adoption of the state constitution, all the way through to Roe and after. And the court said the fact that there's a long history of criminal prohibitions in the state doesn't imbue those statutes with any constitutionality. And there's a long history of other laws under state law that we would recognize today, if they were subject to constitutional challenge, are in fact unconstitutional.
So if the right to abortion is in the Idaho Constitution, based upon provisions that were drafted in 1890, is it your position that the founders of Idaho put that right in there intentionally, or they put it in there unknowingly, and now it's sprung to life because of what happened in 1973?
I think the wisdom of the framers of the Idaho Constitution was that they included language there that reflected a particular philosophy about the natural and inalienable rights of people. And at that point in time, that only meant men, because women were not given the right to vote in Idaho until 1896. But the language in the Idaho Constitution, particularly Article 1, Section 1, precisely the same language that has been recognized in other state constitutional traditions, as including this right to decisional autonomy, the inalienable right to enjoy and defend life and liberty. And so I understand Your Honor's question, and I understand this relates to theories of living constitutionalism and originalism, and I don't think we need to get into that debate today. But what I will say is the respect for individual liberty that is manifest in numerous provisions of the Idaho Constitution has led this court to recognize a right to procreation, which is not explicit in the language of the Constitution, as well as a right to privacy, which is not explicit in the Constitution, that goes far broader than anything that's present in the U.S. Constitution. So bracketing this discussion about what particular philosophy to adopt in interpreting the constitutional provisions, there's nothing meaningfully different between Idaho's constitutional tradition and what is implicit in Idaho's concept of ordered liberty as from any of the other states, or any particular one of the other states, or all of the other states, that would require a different result here. And so to go back to Your Honor's first question, I grant that there's a long history of criminal prohibition on abortion in Idaho, but that was the same was true of any number of states that have reached the conclusion that their constitutions protect the right to decide whether to terminate a pregnancy. It's also the case, and the Kentucky Supreme Court, or Supreme Court of Appeals, addressed this in State versus Wasson, that there was a very long history of criminal prohibitions on homosexual sodomy. And notwithstanding that, the court recognized before Lawrence versus Texas that the Kentucky Constitution recognized the right to privacy that entailed privacy in making decisions about who your sexual partner is going to be. So this long history of criminal prohibitions on all sorts of autonomous decision-making and privacy doesn't necessarily preclude the conclusion that today the Constitution recognizes and respects the right that we're urging the court to recognize here.
Mr. Schoenfeld, I'd like to get to a question that sort of goes away from the merits and more to our jurisdiction, as raised, I think, by the state in their motion to vacate the stay and to deny this petition. But as I understand our law, it is that there are essentially two grounds or two different ways to get before us on an original action. One is the two-part test that's statutory, and the other is under this constitutional violation of an urgent nature workaround or level of getting matters before the court in an emergency way. And if we are to continue the stay in this case, what is urgent about this case being heard immediately so as to allow us to continue to exercise jurisdiction?
So I think if there is a stay of indefinite duration until this court conclusively determines the constitutionality of the statute, and that's clear from the court's order, I don't know that there is any urgency. Certainly when we filed these, there was urgency for the court to act, and it was urgency of a scope that was sort of on par with Reclaim Idaho, where I think the issue was a 60-day window, and Reagan versus Denny, where it was a 90-day window, and it was even smaller here. If the court decides to stay these cases, and the stay is durable, and it would only be vacated upon, again, a conclusive determination of the constitutionality of the statutes, I don't know that there is the requisite urgency for this court to act. I will say, though, that the court has retained jurisdiction in original jurisdiction proceedings even while staying the underlying statute. So I don't know that it necessarily follows that the entry of a stay divests the court of jurisdiction because there is no urgency. I think the need for clarity about what the state's law allows or requires is manifest, and whether that is, triggered by the effective date of August 19th or August 25th, or whether it's triggered by some decision in district court, I think it remains clear that this court's intervention and ultimate determination is warranted.
One of the arguments you've made in your brief for us holding on to the case here and not remanding it down to a district court for fact-finding is that there isn't really fact-finding needed. These are all questions of law. Yet in your opening petition in both Senate Bill 1309 and Senate Bill 13805 and the supportive brief, you've cited to numerous medical journals, like the American Journal of Obstetrics and Gynecology. Doesn't that suggest that we're going to have to weigh and consider scientific evidence? And isn't that type of evidence best reviewed by a trial court rather than an appellate court?
So two answers. The first one is the record in this case is very similar to the record that this court has been presented with when it's decided other original jurisdiction cases, including Reclaim Idaho and Ibarra. In both of those
cases, I would respectfully disagree with that, because those had to do with complicated histories, but they were all related to law and legal operations. This is going to require medical determination if we're going to look at viability, if we're going to look at a 6-week heartbeat law. Don't those things cry out for medical testimony? That's very different than what we did in Reclaim or what we did in Reagan versus Denny.
Respectfully, I don't think so. I think that the unconstitutionality of these statutes and the constitutional questions that are presented to the court are legal questions, and they're apparent from the face of the pleadings. I think to the extent that there is factual evidence in the record about medical necessity, that really goes to some of the equities on the stay questions and not necessarily the constitutionality. I mean, deciding whether to recognize, for example, a right to terminate a pregnancy is deciding whether that's recognized under the Idaho Constitution. That's a pure legal question. Whether in applying strict scrutiny, the state's interest outweighs the woman's protected interest in deciding whether to terminate a pregnancy. That may in some cases require some weighing of medical evidence, but there's a total ban at issue here. There's no weighing of the evidence necessary. The total ban eviscerates the protected right entirely. And so if that's the question that the court is ultimately going to decide, I don't think there's any need for any factual determinations or any adjudication before a fact finder.
But what about your vagueness challenge? I mean, you went on at some length. That seems to be your leading argument against the total ban, and you're talking about what a reasonable medical professional could or could not understand on the affirmative defenses. We need some testimony to establish that, and shouldn't your opponents have the opportunity to test that by presenting opposing testimony?
I'm certainly happy to give the state the opportunity to present that with opposing testimony. I think the record before the court is clear, however, that we satisfy the standard for a facial challenge for vagueness because medical providers, I don't think there's any dispute in the record that medical providers can't know what a medical emergency is, can't know whether a particular abortion is necessary to prevent the death of the mother, nor can they know whether on the face of a criminal record, someone has reported a rape or an incest that satisfies the Idaho statutory definition for those crimes as is required to make use of the affirmative defense for rape or incest. So I don't think any of those things actually turns on testimony. Again, if the court concludes that that requires some sort of factual adjudication and determines that the best course here is to send this case to the district court, I completely understand and obviously respect that judgment, and we've got no cavil with that. But in the meantime, the statute needs to be stayed to ensure that women have access to abortions because the showing before this court, and I think in Ibarra the court made clear that, I think the language was accepting the allegations in the petition as true, they have stated a violation of the Constitution. And I think that's the standard that ought to be applied here, certainly at least in determining whether to stay the statutes pending ultimate determination on the merits of even the vagueness challenge.
But Mr. Schoenfeld, Dr. Gustafson, in her declaration said that women who have been raped or have been incestuously impregnated are unlikely to bring a criminal case under those circumstances. The law requires that those be prosecuted or brought before a prosecutor in a criminal case for an abortion to be performed under those circumstances. Isn't that a factual question that has been presented to us?
I don't think so. I think the vagueness challenge to the rape and incest affirmative defense to the total abortion ban, the vagueness challenge there is that a doctor is called upon to review a report from a competent authority to determine whether rape or incest has been reported to that authority. That requires a doctor to make all sorts of legal judgments about the degree of consent that may have been present in the sexual encounter, about the level of consanguinity between the alleged offender and the victim, to determine whether that qualifies as rape or incest under state law. And it's those circumstances, in order to be able to invoke that affirmative defense on the other side of criminal investigation, prosecution, and potentially being presented to a jury, that renders the statute vague. I don't think the question of how frequently victims of those crimes report them to competent authorities is relevant to the vagueness determination, at least. And I think Dr. Gustafson's declaration points up the folly of relying on police reports as the basis for determining whether the rape or incest exception can be, or affirmative defense can be invoked. But our challenge, at least on vagueness grounds, is to requiring medical providers to interpret those reports in order to be able to rely on the availability of an affirmative defense at some point in the future to actually perform an abortion at that point in time. I'm happy to sit down and then return for my 5 minutes of rebuttal. Thank you.
Very well, sir. Thank you. Ms. Lorano.
Good morning, Your Honor. Mr. Chief Justice, may it please the court and counsel. This court posed 6 procedural questions in these 2 cases to the parties in its order-setting hearings, and there's basically 4 answers that I can give to you. To answer each question in turn, yes, the court should vacate the stay of the Heartbeat Act civil action. No, the court should not stay the trigger law. Yes, the cases should be consolidated and disposed of on the legal grounds that there's no constitutional right to abortion or there's no original jurisdiction, as this court has discussed with my friend. And the court should not transfer either petition for factual development because each petition can be resolved on questions of law. And I'd like to tee off on a discussion the court was just having with my friend about this factual development issue. These are facial challenges, and they can be resolved and should be resolved solely on questions of law. The factual allegations that petitioners have put into the record are completely irrelevant to this court's decision of this case, and they should not be considered when the court is deciding this case on the merits. the fact that petitioners are alleging that the state has no dispute with some of their factual assertions about whether medical providers can understand these exceptions is utterly inaccurate and utterly irrelevant because, again, these are questions of law about whether for example, the trigger law claim is facially vague. To the extent that the court does decide to decide these claims, it needs to consider factual allegations. I completely agree that this case is inappropriate for the exercise of original jurisdiction. Factual development, such as in Wilson versus the Land Board, is appropriately done by the district court. But again, I return to my point that factual development is not necessary or appropriate to resolve these factual questions. And I'll talk about the vagueness issues.
Before you get there, I want to go back to something Mr. Schoenfeld said, and that was that he thought all three petitions should be consolidated. Do you agree?
Yes, Your Honor. We agree all three petitions should be consolidated and denied either based on the lack of a right to abortion or on the fact that original jurisdiction is inappropriate. So to return to the due process argument about vagueness, I'd like to talk about how my friend said that medical testimony, only their medical testimony establishes that the exception of an abortion being necessary to prevent the death of a woman is unconstitutionally vague. And respectfully, Your Honors, that reads a vital part of the statute out of the statute. The statute says that only the physician in his good faith medical judgment needs to determine whether the abortion is necessary to prevent the death of the pregnant woman. This provision on a facial challenge sets the standard and gives the physician the discretion to decide whether that standard has been met. There is no vagueness issue there.
How do we decide what good faith medical judgment means? Typically, for example, in a malpractice case, we have to know what the standard of care is. Don't we need to know a standard of care here to determine what a good faith medical judgment is?
Well, certainly, Your Honor, and to the extent, I'm not going to agree that you need a standard of care to discern what good faith medical judgment means. I think that it goes to courts all the time, and so to parties to prove good faith versus bad faith. That's a pretty common legal question that doesn't require some sort of esoteric standard to be set by the legislature. But even if it does, on the fuzzy edges of the physician's judgment, on this facial challenge, the only question this court needs to ask itself is, are there circumstances, any circumstance, in which a physician can fall within the exception, can know what his conduct is acceptable? And certainly that situation is present here.
But wouldn't the standard of care provide basically the affirmative defense here?
Certainly, Your Honor. Yes, that's one way that the physicians could establish that the affirmative defense has been met.
And one of the questions in my mind, counsel, is where we're talking about affirmative defenses that would apply to a medical provider, and none of us are medical providers, are we able to sit? Because what I understand you to be saying is we should decide the facial challenge just on the face of the language of the statute. And the question in my mind is, where I'm not a medical provider, can I make that determination, or do I need some input from a medical provider?
No, Your Honor, the court does not need input from a medical provider to know that on a facial vagueness challenge that a physician can understand in his ordinary meaning of the language what is prohibited and what is allowed. It's just that the physician needs to determine in his good faith medical judgment that the abortion is necessary to prevent the death of the pregnant woman. And certainly, I think my friend would admit that there are circumstances where a physician can make that determination. And
right, but what about some other phrases like clinically diagnosable pregnancy?
Well, Your Honor, the phrase clinically diagnosable pregnancy is easily understood in its ordinary and common meaning. In fact, I would point to the fact that this has been part of the definition of abortion for a very, very long time, and petitioners have been providing abortions under that definition for many years and not had problems with understanding that definition until today. With regard to the concern about the language best opportunity for the unborn child to survive, again, that just has to be determined by the physician in his good faith medical judgment. There's no requirement for criminal statutes that every single word need be defined. There is enough here for a physician to know, broad strokes, when something is prohibited. And I think my friend again takes issue with kind of the fuzziness around around the practical application of the statute, and that's not where this court needs to focus for a facial challenge. This is an as-applied challenge. I'd also like to return to this court's dialogue about the stay and the interplay of the stay with the court's original jurisdiction.
Hold on a minute.
Yes.
Before we leave vagueness.
Yes, Your Honor.
It seems to me that I think the statutory scheme that we have here between Title 18600 and Title 8800, that it's a bit of a maze given the procedural history. At this point in time, has the total ban gone into effect?
Has 622 gone into effect?
Correct.
No, Your Honor.
All right.
It goes into effect on August 25th.
Okay. And at this point in time, has the fetal heartbeat trigger been triggered?
I assume the criminal prohibitions. No, Your Honor. They go into effect on August 19th.
Okay. So the state is anticipating that both of those things will happen and that both of these pieces of legislation will become effective.
That is correct, Your Honor.
Okay. If we look at, I believe it's 8804, and the language that says if both statutes are effective, that the total heartbeat bill supersedes that section. What does that mean?
Well, certainly, Your Honor, that section means that the criminal prohibitions of the Heartbeat Act will be superseded by the more restrictive criminal prohibitions of the trigger law.
The problem that I have is if you look at Chapter 600, if you look at just the structure of the statute, the criminal prohibition is all in 622. It's the criminal prohibition, it's the penalties, and it's the affirmative defenses all in one statute. That provision is being incorporated into 8800, 8804. If you look at 8804 in its present iteration, it's only the penalty provision. It's the penalty provision, it's the trigger provision, and it's the superseding language. That's the 1, 2, 3. And if you look at 8800, what you've got is the criminal liability language set forth in other sections that are not being superseded. So at the end of the day, when we put these cases together, are we looking at a statutory framework where we have two different criminal liability sections, criminal liability standards, sitting side by side because of the way that this legislation has emerged?
No, Your Honor, and that is because, both because of the express kind of superseding provision that's in the statutes we talked about, but it's also because this court looks to legislative intent. And I think that if the court looks at how these laws have been enacted, it's very clear that the legislature intended the trigger law to be the criminal prohibition that controls.
So does 8800, the entire chapter, does it disappear when the total ban goes into effect?
I think that that is a plausible reading of the Heartbeat Acts, including the civil action based on the issue this court identified, that Your Honor, identified with the language of this chapter. I'd like to very quickly, Your Honors, turn to the question of the interplay of the stay in the original jurisdiction and just point out that, as Your Honor pointed out, original jurisdiction turns solely on urgent necessity. And I have looked back at this court's original jurisdiction decisions for at least the last 20 years, and they've always required urgent necessity. If this court were to stay these laws, their urgent necessity completely disappears. And that means, I think, that this court does not have the ability to stay these laws when exercising its original jurisdiction.
Let me ask you this then on the issue of urgent necessity, and it's an issue that I'm not sure is squarely raised by the petitioners, but I think it's something that we all recognize, which is the extremely unique circumstances of this case, where we have a fundamental right defined by the U.S. Supreme Court being reversed and taken away by the U.S. Supreme Court. Me and my law clerks have racked our brains trying to find any historical precedents for that. It's pretty much unprecedented. The closest thing I can think of that has nothing to do with the courts was prohibition, the 18th Amendment, and then it was repealed a few years later. Does the fact that we're talking about a right that we acknowledge at one time was considered to be fundamental and is now not, does that not create the type of extraordinary circumstance that would cause us to stay this and take a good look at it before we move forward?
No, Your Honor. I heartily disagree. Because that if this court thinks that that is remotely appropriate, that would be something that would defeat the purposes of original jurisdiction and urgent necessity. If I could quickly turn to my friend's...
I want to be clear what you... I'm not surprised that you disagree, but I want to make sure I understand what you're disagreeing with what I said.
Yes, Your Honor. I disagree that this court has the ability to stay a law and thereby defeat the grounds for its exercise of original jurisdiction. I understand Your Honor's concerns about the importance of coming to a reasoned decision on this case, but certainly that cannot trump the constitutional limits on this court's exercise of its original jurisdiction.
Okay, thank you.
With regard to my friend's arguments about the Idaho Constitution, there is no express guarantee to the right to abortion under the Idaho Constitution. And this court, when it has found fundamental rights in the past, has looked to whether they were expressly guaranteed by the Constitution. But ultimately, the question is, what did the framers intend when they drafted the Idaho Constitution? And there is no way that the framers, the drafters of the Idaho Constitution, were thinking that they were enshrining something as a fundamental right that was criminally prohibited at the time that they were drafting the document. My friend argues basically that we should ignore that fact because the Constitution is a living document. But that flies in the face of this court's precedent as to how it interprets the Idaho Constitution. It is not the place for this court to be deciding what's best for Idaho now. It's a place for this court to be looking at what the Constitution, what the drafters of the Constitution intended. And I think that this court would be well served to follow the analysis that was used by the U.S. Supreme Court in Dobbs when it interprets the Idaho Constitution. And in Dobbs, the court focused on what was the understanding of the right to abortion when the Constitution was adopted, when the 14th Amendment was adopted, excuse me. And it emphasized the fact that 3/4 of the states criminally prohibited abortion, and that even if abortion was not a crime at common law, there was no indication that it was a positive right. And no state or federal court had recognized a right to abortion until shortly before Roe was decided. And I'd like to note my friend's point that basically because the law hadn't been challenged, it must necessarily have been viewed as a fundamental right. And I take serious issue with that argument because it doesn't make sense, frankly. There's no way the framers could have thought, oh, well, this isn't being challenged. Nobody has an issue with it. We're going to enshrine this as a constitutional fundamental right. And also, to go to the point about a right to procreation being in the Idaho Constitution, that was a misstatement on my friend's part. This court has never recognized a fundamental right to procreation under the Idaho Constitution. If you trace the cases back that have analyzed this question, they were relying on the federal Constitution and Roe versus Wade. So there's no fundamental right to procreation. And then as wait
a second. Roe versus Wade has nothing to do with the fundamental right to procreation. Are you thinking of Griswold or any of its progeny?
Your Honor, the cases that said that there was a fundamental right in dicta under the Idaho Constitution were tracing, if you trace back their citations, they were citing to Roe and to, I think, Griswold. But they were not citing to any analysis or interpretation of the Idaho Constitution.
Thank you, ma'am. Your time is over, but you're welcome to continue, but it will bleed over into your
yes, Your Honor.
co-counsel's time.
The last point that I'd like to make before I allow my esteemed counsel time to talk is that this court, in interpreting its constitutional provisions of the Idaho Constitution, has been strongly guided by how the U.S. Supreme Court has interpreted the federal Constitution when there's an analogous provision unless there's a really good reason that Idaho's history and circumstances compel a different reasoning. And here, looking at the decision in Dobbs and looking at Idaho's history and circumstances, there is no good reason to deviate from the U.S. Supreme Court's decision in Dobbs and its interpretation of whether the due process clause and an implicit right to ordered liberty contains a right to abortion. And with that, Your Honor, I respectfully request that the two laws not be stayed. Thank you.
Thank you, ma'am. Madam Clerk, how much time then remains for the interveners? Sir.
14 minutes it is, Mr. Chief Justice. May it please the court, I'd like to address Justice Brody's discussion about the interaction between 622 on one hand and the Fetal Heartbeat Act on the other hand, and I'm doing so because I think it gets us into some profoundly important issues here. It's going to get us into this. The legislature's paramount interest here is in the termination now of the stay of implementation of SB 1309. The Fetal Heartbeat Act. That's the legislature's paramount interest. They've raised certain challenges against the Heartbeat Act, but vagueness is the kind you've all been talking about is not one of them. Mr. Schoenfeld conceded that. The only vagueness argument they raise has to do with the statutory damages provision. The Fetal Heartbeat Act, let me answer your question, and you were addressing, in my judgment, the right section, which is $8805. See, the superseding language is not in 622, not in Chapter 6. The superseding language is in the Fetal Heartbeat Act itself, Chapter 88. And it very carefully distinguishes between section and chapter. What it supersedes or says will be superseded come August 25th is criminal enforcement, executive branch enforcement of the Fetal Heartbeat Act. It will not terminate private enforcement through the private cause of action created by 8807.
So what's the violation of the chapter? I mean, that 88, Section 8, or I guess Chapter 88, 8800 has multiple standards.
The standard is different for the Heartbeat Act than it is for 622, for chapter 6. And I direct your attention, for example, to 8801, the definitions, where it defines medical emergency. You look at the very end of that definition, it makes a reference to substantial and irreversible impairment of a major bodily function. Why is that language in there? Well, if we've read the federal complaint filed yesterday, we know why that language is in there. And we also know, I believe, Department of Justice can speak for itself, why their complaint challenges only 622 and does not challenge the Fetal Heartbeat Act. The Fetal Heartbeat Act is sound and valid, constitutionally and in every way. And the civil enforcement provision of it is entirely valid. The separation of powers doctrine doesn't apply.
Maybe this is just completely tactical on your part. Forgive me for not understanding and seeing it clearly, but I'm confused at the legislature's priority of the civil sanction statute as opposed to the total ban in 622. It seemed to me that the 1309 was an effort to work around Roe versus Wade by having non-state actors enforce abortion prohibitions. I think that was what the intent of it was, is to get around Roe versus Wade. Well, now that Roe versus Wade had been reversed, why isn't 18622, which criminalizes abortion, the Idaho legislature's priority?
Okay. I said that's the legislature's paramount interest. Its high interests certainly go to defending 622, certainly go to defending criminal enforcement of the Fetal Heartbeat Act. But in the circumstances of this case and the dynamics of the case and the kinds of challenges that are being raised, if you will look at the Fetal Heartbeat Act, I think you will readily conclude that when you come to this controlling issue of likelihood of success on the merits, the Fetal Heartbeat Act stands. The separation of powers argument falls apart. This act, which provides for both civil enforcement and criminal enforcement, private enforcement, executive branch enforcement, there's nothing unusual about it. I want to challenge, respectfully, this characterization of the purpose for the exclusive private enforcement mechanism. That wasn't to get around Roe against Wade. That was to assure that it be this court that applies the Idaho Constitution to this Idaho law of profound importance to the legislature and to the people of this state. Now, had that challenge been brought here, actually it was, before Dobbs, you would have been bound to apply the Roe-Casey jurisprudence against the Fetal Heartbeat Act. That act had no intention to avoid judicial review. Its only purpose was to assure where that judicial review would take place. And there are powerful and legitimate state interests in having that review take place here. Perhaps initially, under original jurisdiction, certainly ultimately. Now, what has changed, and this has completely undercut, moved the ground out from underneath their separation of powers argument, what has changed is what has happened in the weeks since they initiated their challenge to us, to the Fetal Heartbeat Act. Of course, Dobbs overruled the Roe-Casey abortion regime in its entirety, that there's no federal constitutional right to an abortion. Then, rightly so, the 11th Circuit in Sister Song, upheld the Georgia Fetal Heartbeat Act against a state constitutional challenge, federal constitutional challenge, excuse me. And so that triggered executive branch enforcement of these laws. First to go into place will be on August 16th, executive branch enforcement of the Fetal Heartbeat Act, which will endure for all of about 1 week until the 25th. But then you will have what the legislature envisioned as its permanent enforcement solution. What is it? The permanent enforcement solution is executive branch enforcement through criminal law of all unlawful abortions in this state.
Hold on just a second. Let's look at that assertion and run it through. This is 1309.
I'm sorry.
Sure.
Thank you. Excuse me, Your Honor.
Oh, sure. So Senate Bill 1309 breaks up the Fetal Heartbeat Act a bit. What it does is it creates in 8804 what I'll call the criminal liability standard. And then 8805 is the penalty provision. It's the penalty provision and the superseding language and the trigger language. What happens, and I appreciate the history that you've just walked through, I mean, a lot has changed in the last 90 days and continues to change, and is very challenging for all of us to sort through. But when I look at these, when the dust settles on August 25th, and both of these laws go into effect, I don't know exactly how to read that superseding language. I don't know what happens with 8804. If you look at the standard, the criminal standard in 8804, that is much different than the criminal standard that seems to be incorporated from 18622. And so now we have these two competing criminal standards, you're saying executive enforcement mechanisms, that seem to provide two very different statutory schemes for medical providers. And I don't know which one it is, and I don't know how it works.
Well, let me try to help.
All right.
First, I'm going to respectfully disagree with your characterization of 8804 as the criminal standard. That's true, but only partially true. That is also the civil standard for the civil private cause of action. There it is. Okay, so what is left for civil enforcement? It's a subset of all unlawful abortions in this state. There's no civil enforcement of all of them, only a subset. What's excluded? Abortions occurring before detection of a fetal heartbeat and certain emergency room abortions. And that's embedded in the Chapter 88 definitions. So you have smaller, it's a subset and it's smaller, but that's what the legislature has chosen to have enforced through these private cause of action by these private attorney generals. The vision is, the scheme is, the legislative logic is, and that the executive branch will enforce not only those unlawful abortions, but also the additional ones.
So 8804 is the civil standard and 8805 is the criminal standard.
It will be, 8804 will be strictly a civil standard come the 25th.
Right.
Because there will be no criminal enforcement of 8804. It'll be subsumed or superseded into the broader criminal standard of 622, of chapter 6, excuse me.
So does 8805 just disappear?
It's superseded, as it says in its own subsection 4, shall supersede this section, not this chapter.
Right. No, I understand the distinction.
Well, this maybe give you an idea of why I can stand here and say that the legislature's paramount interest here is in the termination now of the stay of implementation of Senate Bill 1309. You know, that's so for two reasons. Number one, that stay is perpetuating in Idaho the Roe Casey abortion regime, which as of June 24th was stripped of all legitimacy. It has none. Yet it's still operating in this state because of that stay. Second, and more profound, more serious, because of that stay, preborn children are being killed in Idaho, contrary to duly enacted and wholly valid statutes. So if you focus on the Heartbeat Act, among the many things you must focus on, you'll lift that stay. And, you know, the legislature hopes that's today. I have no time. But
Thank you, sir.
Open to questions.
Appears there are none. Thank you. Madam Clerk, how much time remains for the petitioner? Sir.
Thanks very much. If I might, I'll start with SB 1309. I think one of the things that may have emerged from the colloquy among counsel and the court is that the operation of this scheme together is quite vague, and there are no clear rules of the road going forward. And obviously, the court's intervention to clarify what those rules of the road are, and our submission is that the same set of standards that has obtained in the states for the last 50 years is the right status quo to preserve while this litigation is ongoing. With respect to SB 1309, the private civil enforcement, as I understand the legislature's position, there will be no governmental enforcement of the fetal heartbeat ban once the total abortion ban becomes effective on August 25th. And so what I understand from counsel for the legislature is that on August 25th, when the dust settles, at least provisionally, there will be an outright criminal prohibition on all abortions in the state, as well as a private civil enforcement mechanism for violations of an inoperative criminal prohibition on abortions performed after the detection of a heartbeat. In those circumstances, the separation of powers argument that we've made to challenge the private civil enforcement mechanism retain all of its force as in our briefing. In those circumstances, you have an underlying criminal prohibition that is categorically unenforceable by the state and is enforceable only by private parties, subject to all sorts of bells and whistles that violate the Constitution for any number of reasons. But to go to the separation of parties argument, that scenario that counsel for the legislature just laid out is precisely what this court identified in Meade versus Arnell as a paradigmatic violation of the separation of powers under the Idaho Constitution. So that is the scenario that the legislature intended. That is the scenario that the legislature envisions. It violates the state separation of powers and should be struck down on that ground alone. And it should be struck down now rather than having a circumstance where somehow is operative between August 19th and August 25th, only to become inoperative because on August 25th it begins to violate the separation of powers in the state. Not conceding that 6 days of of government enforcement of the criminal prohibition would render it constitutional, but there's no reason to contemplate that 6-day window as an answer to the separation of powers argument. But there are other reasons why the civil enforcement mechanism violates the Constitution. It's a special law. It violates the state's equal protection guarantee. It subjects abortion providers, unique among all healthcare providers, to private civil claims brought by a broad universe of potential plaintiffs with statutory penalties, not subject to any limitation or any standard for adjudication, and a 4-year statute of limitations.
You say it's a special law, but don't we have those kind of status-based laws that haven't been challenged all over the place? For example, whistleblower laws, landlords could be liable for trouble damages. I mean, how is this any different than those?
Well, so there are, the whistleblower law, I think, is one that I'm not sure what particular features of the whistleblower law you have in mind, but the standard for whether a law is special is whether it identifies some particular class of claims and whether it's arbitrary, irrational, or otherwise. And our argument is the combination of special features for this disfavored conduct, lawful but disfavored conduct, is renders it special. The 4-year statute of limitations, there's no justified departure from the default 2-year statute of limitations for wrongful death. The broadening of the universe of people who can sue under the statute, there's no justification for broadening it beyond the people who...
Again, I'm having a really hard time. You're saying the legislature doesn't have the discretion to set the statute of limitations on things, and if they do it in one area, they can't lengthen it in another area?
I'm saying that the standard for a special law is whether it is arbitrary, capricious, or unreasonable, and that's the burden that the legislature has in enacting a law that regulates a particular class of claims. This one is different from creating a new claim and attaching a statute of limitations subject to ordinary principles. The most analogous law here, the most analogous private tort, and I think the legislative history that Justice Brody, you and counsel for the legislature got into, or perhaps it was you, I forget, I think illuminates why they adopted these particular features, but they're not rationally tethered to any aim that the legislature intends to accomplish. Their view was, and I realize I'm running out of time, I apologize. I just want to make one critical point with respect to vagueness, if I might.
I'm fine, go ahead.
I apologize, but I do want to return to counsel for the state's position that if there are fuzzy margins, they are remote from a facial challenge. The United States Supreme Court made clear that where there are criminal laws at issue in a vagueness challenge, the fact that there is, quote, some conduct that clearly falls within the provision's grasp doesn't save it from a vagueness challenge. We are talking about a criminal provision in an area where the standards that the legislature has enacted have no relationship to any medical consensus. There is no way a medical provider can do anything in good faith given the indeterminacy of the language in the statute. And I say that my time is up, so thank you.
Thank you very much, Counsel. Counsel, to all parties, we appreciate the briefing and the argument today. This matter is under consideration by the court under our Rule 5, and we will render decisions accordingly. Thank you.